All right. I want to thank some of you guys for the channel. My YouTube channel, the Winner Circle, seems to be growing, and I'm very thankful for it. Everybody participated, which is a great thing. It is a great thing. So I'm going to start with my scent of today, which is Xerxes Renaissance, and we're going to keep it moving because why not? Okay, so we need to understand what, when we're getting in these relationships with these banks or financial institutions, that they are your trustees. And it's easy to see that they're trustees because you're giving them property to be held in lieu of a certain action. Okay, so when you sign for a home loan, you're giving them a note, a promissory note to fund the transaction. They're acting as if you owe it, but technically it's something they owe. But I mean, if they can get away with it without paying, I mean, it is what it is. So if a trustee shall destroy the trust res or should sell it to a purchaser without notice of the trust and dissipate the purchase money, the Cestui trust may maintain a suit in equity against the trustee for breach of trust and recover a sum of money, either the value of the trust res or the amount of the profits which should have occurred if no breach have been committed. I hope you understand that. So when they're saying that, you see how this conforms with the Uniform Commercial Code. And this is 3-305, defenses and claims and recoupment. So section A, except as otherwise provided in this section, the right to enforce the obligation of a party to pay an instrument is subject to the following. 1A, defense of the obligor based on infancy or the obligor to the extent it is a defense to a simple contract. Duress, lack of legal capacity, or illegality of the transaction, which under other law nullifies the obligation of the obligor. So what happens is when we're getting in these agreements, everybody's talking about they lack disclosure, they lack their fraud, their adhesion contracts, but nobody's doing anything about it. I mean, if you sit there and talk about something that's happening or occurring, and you do not try to remedy the situation or fix the situation or correct it, then you are the problem. It's not the banks doing anything to you, it's us doing it to ourselves. I hope that makes sense to everyone. Fraud that induced the obligor to sign an instrument with neither knowledge nor reasonable opportunity to learn of its character or its essential terms, or discharge of the obligor in insolvency proceedings. So we have to understand how the Uniform Commercial Code connects to a so-called trust obligation. And why is all this property placed in trust? Okay, a trust is basically an arrangement. So everybody thinks that a trust has to be done by three parties. It doesn't. A trust basically is a relationship to where somebody is holding property in lieu of someone else. So the way that the system is built is the system is a interdependent system. So you're never going to be a millionaire by yourself. That's just the way the system works. So to keep it to where people are making profits and making proceeds, they have to make the system to where it's interdependent. Okay. So that's why you hear some of these people who are like, "Oh, you don't pay your rent, you're gonna crash the mortgage, the market. You're not paying your rent. You're not doing this. You're not paying your mortgages. Good luck." So you always have slaves that try to keep you in slavery and bondage, and you always have people trying to free you. Remember, I've said this many times. There are some people who want Rome to burn, and then there are some people who want to stop Rome from burning. You're always going to be in that situation. Now let's go back. All right. So amount of the res. Okay. No breach of his rights is a personal right against the trustee. It is an equitable obligation. But while the trustee still holds the trust res, the right of the Cestui trust is of a different nature. On the question, how far is it different? There is a great diversity opinion. On one side, there's lined up Koch and his great train of disciples, together with Langdale and Ames, uh, Maitland, and Holland. Okay, let me go ahead and zoom into this because I can barely see this. I'm getting old. Maitland and Holland, and the leading commentators of law of use of trust in trust. Sanders, Gilbert, and Lewin. In the other camp are found Austin and Salmon, and Pomeroy, whose views have recently been able uh, championed by Professor Houston. Occasionally, some heat is endangered. Engendered. I'm sorry, in the conflict. Professor Mainland allows himself to the luxury of almost Austinian vigor of expression when he says the Austin's uh, contention that in equity, a specific enforceable contract to sell property at once vests jurum in rem, or ownership in the buyer. So basically, in equity, what they're stating is the buyer is the controller of the agreement, because really, when you get into it, the buyer is the donor. Okay. As a piece of speculative jurisprudence, this seems to me nonsense. While an exposition of English rules, I think not merely nonsensical but mischievous. It is the purpose of the writer briefly to outline the arguments on each side of the question. The creation of the use or trust has always been regarded as a legal transaction quite different from the creation of a contract. But to keep it 100, a contract is basically a trust. You know what I'm saying? People try to use semantics, etc. But if somebody is, if you have a contract, the contract may have a different dynamic nature. Like I could have a contract for you to paint my house, and that's why a contract and a trust may differ. But essentially, when it comes to conveying property or transferring property, a contract basically acts almost in the same light as a trust. In the first place, when a property is transferred by one person to another, to the use of or in trust for a third person, there is not and there has never been any doubt of the right of that third person to enforce the use of or trust. Now, when you get a car loan, what happens is a trust is created by, if you go through the dealership, the trust is created through the dealership, meaning once you sign the purchasing agreement, the dealership takes that purchasing agreement and transfers it to a bank. Okay, thus creating a relationship between the bank, who is the servicer, not the lender. Remember, the bank is not lending you any money. They're agreeing to service the contract. All right. All right. So the creator of the use of the trust in favor of the third person cannot enforce the use or trust, whereas a party to a contract certainly has the right to enforce it. See, what they use is they use these interchangeable terms. And that's why a lot of people on the internet, where some of us are saying the same thing, we're just saying it in a different manner. You know what I'm saying? So sometimes that's what people say, oh, you don't know what you're talking about. And it just takes this, just like this. These are some people who are well versed in law arguing about the difference of a contract. But a contract and a conveyance can be used as a trust. Okay, depending on how it's worded, depending on how it's used. The transaction is regarded in substance as a grant or a conveyance of a beneficial interest rather than the creation of an obligation. Secondly, in spite of that, the fact that in the creation of a use or trust, there's often found all elements which are found in the creation of a contract. See? So what they're basically saying is a trust and a contract can be pretty much the same. Nevertheless, any action at law for breach of contract will not lie against one who holds subject to use a trust, to a use or a trust. It has been suggested that the reason for this is that equity gave relief before the action of special assumpsit arose. So you want to look up the terms assumpsit. So it's hard for me to do this when I'm just going to highlight this so I can come back to it, and then we'll go and see what assumpsit is so you guys understand this. All right. So we'll look at the legal definition of assumpsit, and then we'll go back to reading. So a lot of this stuff is boring as hell. I'm going to keep it 100 with you. But when you start reading this stuff and you start understanding British law and start understanding American law, and you start understanding this stuff, it makes it so much easier to put this stuff together. That's why I do these videos. Assumpsit, Latin, he has undertaken, in common law, an action to recover damages for breach of contract, originating in the 14th century as a form of recovery for a negligent performance of an undertaking. This action gradually came to cover the many kinds of agreements called by an expanding commerce and technology. The concept of assumpsit was first introduced in cases in which the defendant damaged goods entrusted to him by the plaintiff. Okay, so like if you request that the bank is holding the note on behalf of you, and then the bank destroys the note or loses the note, you can sue them because you had a claim to the instrument under the Uniform Commercial Code. Okay, so this is 3-306. Claims to an instrument. A person taking an instrument other than a person having the rights of a holder in due course is subject to the claim of property or possessory right in the instrument or its proceeds, including the claim to rescind a negotiation and to recover the instrument or its proceeds. A person having the rights of a holder in due course takes it free of the claim to the instrument. Okay, in most instances, the banks are not going to be an holder in due course. Why? Because they're taking it subject to your claims and defenses. So what happens is the bank is not the lender of the alleged loan. Why is the bank not the lender of the alleged loan? So you have to understand, what is the difference between a servicer and lender? See, it's not hard to figure this stuff out. It just takes a little bit of, putting your, rolling up your sleeves. Your mortgage lender is the financial institution that loaned you the money. So you need to find out who loaned me the money. Okay. You have a right to know this because they have to disclose it to you. Who loaned me the money? Okay. They're going to say, oh, we're the lender. Okay. I want to see where the source of the funds came from. Meaning, I want to see who paid, where's the check? Okay. You don't have to argue this. You can make them pay out your what they owe you. But I'm just saying, if there's people who like to argue and there's people who like to settle. So your mortgage servicer is the company that sends you your mortgage statements. Your servicer also handles the day-to-day tasks for managing your loan. So you might ask yourself, what's the point of being a servicer? Well, if I'm a servicer, I can make millions of dollars just by holding your note. I could charge fees for processing payment. So if I charge $10 to process a payment, and then I process a million payments, that's $10 million without even owning the property. So then all I would have to do is deduct my site, like say if I have a few sites to process this, the payment of my collection team and all that. That's all I would have to do is deduct that. And there you go. So if you understand why banks don't let you out of your mortgage as easy as you think, because it's bigger than you. Okay. So and that when the action did arise, okay, I'm going to read that over again because that's going to be hard for me just to pick up from there and people to understand where we were at. It's been suggested that the reason for this equity, I mean, this is that equity gave relief before the action of, of the special assumpsit arose, and that when that action did arise, it was not applied to the use of the trust because the law judges thought it unnecessary to give a remedy in the field adequately preempted by equity. But the courts of law have seldom shown such self abnegation as to refuse to give relief merely because relief, even more adequately relief than the courts of law would give, was given across the hall. Moreover, the action of the covenant long intended, I mean intended, I'm sorry, the enforcement of the uses, and yet no case has been found in which the FOFR uh, to use obtain relief in this form of action. No truth seems to be that the creation of the trust has been regarded rather as a grant of a beneficial interest than as the creation of an obligation. See, that's all it takes to create a trust is to create an obligation. You see what I'm saying? So then you can act by an implied presumption, or you can act by, by stating that somebody is obligated to do something. That's like if you get a traffic ticket, you're obligated to go and settle the matter. You're not obligated to argue case law. You see what I'm saying? So like when people argue with me on that, I was like, dude, you don't need to go. You don't need to bring up case law. You see what I'm saying? That's just what some people choose to do. Some people choose to argue. Some people cannot see what's really going on in front of them. Okay. No one stated this idea more. Uh, I can't even see. Succinctly, I'm butchering that, so I'm going to go at then Professor Ames when he says the bargain of the sale of a use as well as the agreement to stand seized were not executory executory contracts, but conveyances. So executory contracts. So you want to see what an executory contract is. The reason why I read a lot of old stuff and a lot of law, because these terms, you have to bring them into modern day. So that's why I don't just look at Black's law or anything. I just look at etymology. I look all over the place. So when people ask me, what do I read? I read a lot, which is different stuff. Okay, so executory. Executory refers to something, generally a contract that has not yet been fulfilled or performed or completed, and is therefore considered imperfect and unassured until its full execution. Anything executory is stated and not yet finished, or is the process of being completed in order to take the full effect at a future time. Once an executory task is accomplished or an executory requirement is satisfied, the task requirement is considered executed. In the same vein, the opposite of an executory contract, a contract under which there are um, outstanding obligation, is an executory contract, an agreement according to which all parties have fulfilled their obligations. Examples: executory terms include, but are not limited to executory bequest, executory sentence, executory judgment, executory contract, executory trust, and executory device. In each instance, as with all executory terms, some conditions must be satisfied or some act yet performed in order for the legal action to be executed. So with that being said, when you take out a loan or a future agreement or a deferred advance, the the act that is missing is the advance being the deferred advance being provided. And that's why the bank owes you an obligation. And you think that the bank, but you have to authorize the bank to be able to process this payment for them to be able to settle the account on behalf of you. Otherwise, they won't be able to do it. And then you're going to be in default, and then they're going to be arguing with you, and you're going to be arguing with them. But they never let you know why they're arguing with you. Okay. But conveyances, thirdly, for the last 100 years, it has been held that a trust may be created by gratuitous declaration, okay, by gratuitous declaration of trust without transfer of legal title. See, this is what I'm trying to tell you guys. Like when you start getting into this, they use different words, they use different things, and it's all the same. You see what I'm saying? That's like when I tell people a child support case is the same as a mortgage case. A mortgage case is the same as a car repossession case. A car repossession case is damn near the same as a criminal case. Okay, it's whatever evidence you allow in is going to create the presumption that the court has jurisdiction to enforce an agreement. Okay, so that's why I try to tell you guys a child support action is separate from a court action. So you have to know this. Just like when you go into court and you're being foreclosed on, a foreclosure action is separate than the actual agreement. They're trying to create a new contract. Okay, that's why people say you must challenge the jurisdiction of the court. In some instances, they're correct. In some instances, they're not. Here again, the reason is it is submitted is that, and there's going to be somebody in my comments, if you always challenge your jurisdiction, not always. Some instances you don't need to. Because I've won cases without doing that. You don't have to always challenge jurisdiction. Sometimes you may need the court to finalize an agreement. Here again, the reason is submitted is that the courts regarded the transaction as a transfer of beneficial interest rather than a creation of an obligation. Of course, these propositions do not consecutively show the character of the right of the Cestui trust. So Cestui trust has multiple meanings. It could say he who lives, he who has a beneficial interest. I've heard some stuff that doesn't even exist. Like some people just be taking stuff and just, man, oh my God, the research be lazy as hell on some of this stuff. So in the early distinction between a grant or a conveyance, an incurring of an obligation was not understood. A debt, for instance, seems to us today to be a clear example of a mere obligation. What did they just say? A debt is an obligation. That means that a debt is not an order for you to pay. You see what I'm saying? So they're saying the same thing that all of us are saying on the internet, but it comes from a lawyer. So most people listen to lawyers and won't listen to people. They'll say, oh, you're not trained in law. If I can read, I can figure out the law. If I can read, I can figure out accounting. I can read the same books that the accountant learned because it's all available to you. You see what I'm saying? You can get that on the internet. I have business books on the internet that a lot of people don't even know exist. And yet, one of these days, I think I might start selling flash drives of my information. So I might just start selling those for purpose, so it can help people to know what to read so you're not all over the place. Okay. Yet, in the early creation of this, and also you got to love this stuff too. You can't just get in this for like, I just want to discharge a house or I just want to discharge a car. It's not going to work for you because you have to actually want to learn this information. You have to be a student. This is a perpetual learning thing. It's not something that you just learn overnight and everything in your life just changes. And yet, in the early law, the creation of debt was regarded as in the nature of a grant. See, you're granting something. So this is why the donor or the person who creates the trust or creates the obligation, they always have the highest claim. Even the Uniform Commercial Code will back that. 16 CFR 433.2 will back that. There's plenty of state law will back that. Yeah, but these propositions do tend to show that the courts have viewed the right of the Cestui trust as something different from a mere obligation, something at least resembling an interest in property. Now, what property are they talking about? They're talking about the instruments. They're talking about the chattel. See, your house is not being put up as collateral. Okay. What's being put up as collateral is the chattel. So the chattel agreement is what you gave them a interest into your property. You see what I'm saying? So when the banks are doing all this stuff and people are like, oh, it's all this misrepresentation. No, you need to learn how to read because you're the one that created all of this. In dealing with what Professor Mainland has called the internal character of equitable interests, that is their duration, transmission, and alienation. The courts of equity have always treated them as more like interest in property than obligations. What? Yes. There's a few brothers on the internet that get this, and shout out to them. That it's all about interest. You see what I'm saying? It's all about the interest in a property, interest in an account, interest in all of this stuff. When you understand it, it's all about that. Okay, the principle on which the courts of equity have proceeded in this, I mean, is that equity follows the law. So you hear people tell you that law and equity are separate. What does this just say to you? Equity follows the law. You can't have a legal contract if it's not equitable, but you can have a legal interest in a contract. Like, look at it like this. That's why I always tell you guys the rules of the streets always apply. When I say that is if you let somebody do something to you in the streets and you don't do something, then what other people are going to see is that they can do the same thing to you until you stop them. Well, what do you think these corporations see when they look at your credit report? When they look at cases you've lost, they think that they could do the same thing to you. Why? Because history shows a history. It shows a history. So look, this maxim means not that equity treats an equitable interest in property as the law treats an obligation or choice in action, but rather that equity treats an equitable interest in property as the law treats a legal interest. See? A legal interest. So if a bank is trying to foreclose on you, you know you can sue the bank for your title. You don't have to, you like a lot of this stuff is like, it's so many ways, it's so many remedies, man. It really is. So in property, okay, so let me read that again because I was yammering over it. I apologize. Um, we'll go back. So this maxim means not that equity uh, treats an equitable interest in property as the law treats an obligation or chose an action, but rather that equity treats an equitable interest in property as the law treats a legal interest in that property. The interest of the Cestui use was held to be assignable. What? Assignable. We are bringing this to you guys, telling you that you can assign your interest, you can assign your debt, meaning you can assign the interest to an account, you can assign it to a collection agent, you can assign it back to the financial institution that says that you owe the obligation. Even in those days when to assign a choose an action um, was illegal on the grounds of maintenance. As early in the middle, as early as the middle of the 15th century, it was held that if a Cestui use dies intestate, his interest in the trust res descends in the same way in which the legal interest in the res would have descended. But this principle that equity follows the law, that equity applies to equitable interests in property, the rules applied by the law to legal interest in the property has not always been fully accepted or consistently applied. Indeed, one of the chief purposes for which uses were invented was to evade the rules of law. Now, let me tell you, because when you get into the legal aspect, you can get into a tangent of arguments that merely are arguments brought up in court incorrectly. So, like, if you don't know what you're doing in court, you can create case law that ruins it for everybody because people read the captions and synopsises of cases and they don't actually read the case. So, if somebody tries to use a case against you, you would need to take that case, open it up, and break it down and say, Your Honor, this case is not even applicable to this matter. All right. As for example, the rule which forbade the devices of land, the courts of equity have had a great reforming influence upon the law of property, largely because they have not in all matters followed the law. Because equity is supposed to be fair, but the law and equity are infused. They were infused. I forgot what year they were infused. I don't know if it's 1938 or 1960 something, but they were infused. Law and equity was infused. Equity, looking to the substance rather than the form, has dispensed with many of the formalities which were dear to the heart of the law. Equity has refused to follow antiquated feudal conceptions founded upon reasons which had begun to lose their meaning when equitable interests first arose. And equity has refused to follow concepts based on metaphysical, pseudo logical sort of reasoning, so common in medieval law as well as in medieval theology, I'm sorry, and science. Okay, so like, I want to get into this, but I don't want YouTube to flag my video again because this is going to get into like vaccines and viruses, etc. A lot of it was based on metaphysical pseudo law, like pseudo logic. Like, if you got to see, I mean, most of you, if you could understand that all of this was a psyop, it was a psychologically operation. And it's not me saying people wouldn't get sick and all this other stuff. I'm not getting into that because some people may have, they have a personal stake in this stuff. I don't care about that. But you see the psychological thing where they had you stand 6 feet away from someone. Like 6 feet away from someone is almost different than standing up close to them. It really isn't. So if you go to a grocery store, regardless if you're wearing a cloth mask or any other mask, you're still breathing in the same stuff that they were telling you that was making you sick, etc., which they were actually making you sicker. But that's not here or there. And I hope I don't get flagged for doing this because our people need to hear this anyway. Although equity followed the law so far as to create equitable estates in land. See, the problem is most of your properties are not even attached to the land. So, like when you're in court, you're actually going after a property, but you don't own the land. So you need to own the land and you need to own the property. That's how you hand down inheritance to your children. That's how you give inheritance to your children, by the land. You're not even attached to the land. They took y'all off the land. They got y'all living in property and you're not even touching the land. That's why you don't own nothing. That's why you don't own anything. Well, technically, legally, you can't own anything anyway. You're just passing through, but you're not touching the land. Your property is not touching the land. You never got your property surveyed and and got it what am I talking about? You never got it reevaluated and placed into your you never placed a claim on the land. That's why somebody could take your house. Yet the old rules forbidding an overlapping of or an hiatus in estates were ignored by equity insofar as it allowed springing and shifting uses. Again, equity did not regard a cestui use or a cestui trust in fee simple as holding of an overlord. It followed, therefore, such such feudal burdens as relief, fine upon alienation, wardship, and marriage were not imposed upon him. And this is the reason why when the Cestui use or Cestui trust died without an heir, the feoffee or the trustee was allowed to keep the land. So now you understand why people, the county has you register your property on the at the county recorders or whatever they call it in your state. The I think it's county recorders or it's recorded in the county, because if you pass, then your property can revert back to the trust if you don't have, I mean, back to the state or to the county if you don't have any heirs. So they're basically your trustees managing your property. And if your property doesn't pass, if you don't put it in a trust, it will go through probate, and then basically it'll go back and get recycled again for use. Otherwise, if they didn't do this, it would just be a bunch of people with a bunch of dead trusts out there with just property just sitting abandoned in land that nobody could take over. You see what I'm saying? So there will be like there will be blocks of like empty homes and just sitting there, and nobody could do anything because nobody had the rights to do it. That's why the system operates how it is. 4, there was no equitable overlord to take the equitable interest by escheat. So you need to understand what escheatment is, and we're going to go into this. I love these law reviews, man. They're so boring, but they're so beautiful. They teach you so much. So we'll go into what escheatment is for some of you guys who don't know that. And I'm glad that somebody is working on getting remedy with my administrative process course. I did a private class, and I'm gonna revitalize it. But I did a private class, and I gave that to some of the people who supported my website and my channel, and I'm gonna be bringing that to the forefront. I'm gonna make some adjustments, and I'm gonna bring it. All right, so we'll go to escheatment, and then we'll understand. Uh, all right, so, and the reason why I use uh, Cornell or this site is easier for a lot of you guys, right? So, escheat is the passing of interest in land to the state when the decedent has no will, no heirs, no devisees. In the United States, escheat rights are governed by the laws of each state. Probate is usually used to determine escheat rights. So now, if you understand this, you guys don't even understand how much game I just gave you. I'm going to save that for a private class, because if I'm doing this, I'm saving that for a private class. Okay, so, oops, my bad. So let me get back to where we was at. There we go. All right. So, interest bias true. Many legal rules which might well have been applied to an equitable interest for a long time were not so applied. The legal rules to courtesy and dower, for instance, were not applied to the uses, nor were the creditors of the cestui use able to reach his interest, right? But when the modern trust grew up from the ashes of the old use, which was so nearly consumed by the statutes of uses. So you want to look up the statute of uses. I'm gonna go ahead and click that. So I'll be trying to gain knowledge from this stuff. So I just sit here and read it. If I see something that pop out, I go copy it, go look it up, I look for that information because I'm always hungry for information. The doctrine that equity follows, the law was given a new impetus. It was seen that a chancellor ought not deal capriciously with equitable interests. That's why I told you guys when they deal capriciously or when they deal in an unjust matter, they all become trustees de tort. Okay, you guys need to understand that. Some of those videos that I gave y'all, y'all think ain't no information in it. Is a lot of information in it. It's just you don't understand. You can't see it yet. You will be able to see it, and you're gonna be like, "Wow, that was a lot of information." That such interests should be governed by definite rules, and it came to be held that the interest of the Cestui Trust is so little like a mere chose in action. I think see it's supposed to be. I think it's supposed to be choice, but they spelled choice differently back in those days. In action, and so much like property interest that husbands were given courtesy and rights during the coverture corresponding to those which would have had a legal estate. And although wives were not given dower in equitable estates, it was only because the doctrine of stare decisis. So now you have to look up things like what was the doctrine of stare decisis. That's why you have to read these. Uh, you have to read. I think we went over this. Uh, yeah, we did go over this. Okay, stare decisis. So stare decisis, the doctrine stare decisis is the doctrine that courts will adhere to a precedent in making their decisions. Stare decisis means to stand by things decided in Latin. Okay. So now you understand the doctrine of stare decisis. This was this. I mean, and this anomaly was finally removed by statute in England and generally in the United States. Creditors of the Cestui Trust were also ultimately given rights in the equitable interest of a Cestui Trust, both before and after his death, corresponding to those which they had in his legal interest. Now you start to see how they set this up. So they basically gave corporations legal and equitable interest in your property, so you have to take it back. Okay, this view that the interest of the Cestui Trust in its internal aspect is more like an interest in property than an obligation has found a modern application in a recent decision of the Supreme Court of the United States in Brown versus Fletcher. The facts were these: a trustee and Cestui Trust were both citizens of the state of New York. How can a Cestui Trust be a citizen of New York? Because the citizen and the Cestui Trust are the same thing. And people are like, oh, it's your birth certificate. Yeah, it is your birth certificate to some degree, but it's really your conduct and agreements. The Cestui Trust assigned his beneficial interest to a citizen of Pennsylvania who brought a suit against the trustee for the enforcement of the trust in the federal district court for the Southern District of New York. Now, the federal statute provides that no district court shall have cognizance, I mean, I can't even say it, cognizance of any suit to recover upon any choice in action in favor of an assignee, unless the suit might have been prosecuted in such court if no assignment had been made. So, like a lot of y'all mortgage cases, y'all need to be moving them to federal court Because the assignment, but I'm not getting into that either. So, anywho, you can move it into federal court, but you don't need to. All right, the Supreme Court was unanimously of the opinion that the district court had jurisdiction. The assignment of interest of the Cestui trust is not an assignment of choice in action. Okay. So what they're saying is just because you assign the interest of an agreement doesn't mean you have a right of action, meaning a right to sue the person, but you do have a right to assign it. You see what I'm saying? So in respect then of the acquisition of the rights of the third parties in it, the interest of the Cestui trust has certainly come to be regarded as a property interest and not a mere obligation. Okay. So that means that you have to assert a claim to your property, as I talked about in my declaration to understand the Declaration of Independence. Okay. We may well say Maitland admits that the Cestui trust has rights which in many ways are treated as analogous to true proprietary rights in jura in rem. Okay, so you guys have to understand when I'm talking about. I've said this many times that you have a proprietary interest to all your loans, your contracts, your agreements, your accounts. You have the proprietary interest. What they do is when you, as we talked about it, once you establish and start doing business, you act as a sole proprietor because your business and you are basically intertwined in one. And that's to learn more about that. Go, you can watch my video, Mind Your Business. Just like when I tell people, if you want to see my old videos, you want to hear my old stuff, watch my old videos. You know, just like Jay-Z said, you want to buy my old stuff, buy my old albums. But even though these videos are free, but you know, the concept is I've already talked about all of this stuff. I've been talking about this stuff for years. Okay. He has a Cestui trust, really rights in rem. A right in rem is usually defined to be a right available against the word at large, correspondence to a duty imposed upon a world at large. And by the world at large is meant indeterminate persons, an indefinite number of persons, not necessarily everyone in the world. And it is distinguished from a right in personam, okay, or an obligation, which is a right available against a determinative persons, corresponding to a duty imposed upon determinative persons. Now, a legal obligation is subject of ownership, okay? So if you don't break up your ownership rights in the interest or property, the bank does not have to hear you. No one does. It is the right, it is the property of the obligee if a third person intentionally and without excuse interferes with this property. What? It is a right of the. Let me go back. See, this old school stuff, boy, is fire. Is fire. It is the property of the obligee if a person, if a third person intentionally and without excuse interferes with this property. He commits a tort and lays himself open to an action for damages. The general duty resting upon all mankind not to destroy the property of another is a cogent in favor of an obligee, as in its favor, as in favor of the owner of a horse. And the violation of this duty is a pure tort. So, like if an attorney firm is trying to steal your house, you could sue them in tort court to stop them. Some of y'all don't know that, but like I'll be telling y'all, it's a myriad of remedies that y'all got. Okay, in the one case as in another, this doctrine of Lumley versus Guy and Bowen versus Hall, an obligee has then a right in personam against the obligor, and his has in addition rights in rem. For he may insist that all the world refrain from interfering internationally and without excuse with his right against the obligor. The creation of the right of a right in personam necessarily results in the creation of rights in rem. And of course, an equitable obligation, as clearly as a legal obligation, is subject to the ownership. It's, it is the property of the obligee if a third person intentionally and without excuse interferes with this property. He has laid himself open to a suit for damages. So that means if a attorney comes into court and they steal your house or they steal your car, you can sue the attorney firm, and then you can make it in relation to the bank. So an equitable obligation, of course, is protected only in equity. A third person who interferes with a guilty or an equitable rather than legal tort is, is true. Therefore, that Cestui trust has not merely rights in personam against his trustee, but also rights in rem rights, which may be asserted against the world. You didn't know when you were going to court, you were fighting the world. This disputable question, therefore, is not as the existence of his rights in rem, but to their extent. Professor Langdale, in speaking of equitable rights, says that such a right is not ownership. That is, he adds, it is not ownership of the thing which is subject of an obligation. For example, when land is held by one person for the benefit of another, the latter is not properly owner, see, of the land, even in equity. So let me say that again. For example, when land is held by one person for the benefit of another, the latter is not properly owner of the land, even in equity. Of course, the equitable obligation itself is much the subject of ownership as a legal obligation. And he further says it may be said that equity could not create rights in rem if it would. And that it would not if it could, and adds here again, when it is said that equity cannot create rights in rem, reference is had to the res, which in the subject of the equitable obligation, regarding the equitable obligation itself as the res. See, that's what I'm trying to tell you guys. Your agreements is the res. You're creating a trust when you have an agreement. When a bank sends you a bill, or when somebody sends you a bill in the mail, that equitable obligation is creating a trust. There can be no doubt that an equitable obligation, like a legal obligation, always creates a right in rem, i.e., an absolute right between the obligee and the rest of the world, except the obligor. Okay? For it can create a right in personam, i.e., a relative right, only as between the obligee and the obligor. To say therefore, that an obligation can create a relative right only is to say that it can create no right whatever, except as between the obligee and the obligor. Moreover, if an obligation does not create an absolute right, it is impossible to support Lumley versus Guy and Bowen versus Hall. You're not understanding, man. Y'all not hearing the game in this, man. This is a lot of game. That's why I try to tell y'all. Everybody be like, "Oh, attorneys is evil." Man, you can learn a lot of game from reading what they talking about. If you understand, you got eyes to see and ears to hear. Thought through, the converse does not necessarily follow. And in another place, he says, it is only by figure of speech that a person who has not the legal title to property can be said to be the equitable owner of it. Okay? So what happens is you have legal title, but you convert it to where you have equitable title. But we'll get into that. Okay, what is called equitable ownership or equitable title or an equitable estate is in truth only a personal claim against the real owner. Okay, so then what they're saying is that what we've been taught is in reverse. They're saying that you have legal title and they have equitable. That makes sense. That really does make sense. So they have an equitable interest and you have a legal interest. That's why they bring you into court. That makes a lot of sense. Now it is just here that the difference of opinion arises. It is submitted that a Cestui trust is not merely the owner of the equitable obligation. See, they're talking about the legal person that is created or the principal of the trustee, but he also the equitable owner of the property held by the trustee is submitted that he has more than those rights in rem, which are possessed by every obligee of a legal or equitable obligation, that he also has proprietary rights in the trust property. It is submitted that the legal analog is not a legal obligation, but legal ownership of the property. Of property. And that to speak of equitable ownership is just as accurate a use of the terms as to speak of legal ownership. 4 reasons have been urged as conclusive, showing that the right of a Cestui trust is an obligation and not a property right. First, that the trustee is owner, okay? And that there cannot be conflicting rights of ownership in the same property. Second, that equity acts upon the person. Third, that the duties of the trustee are positive as well as negative. And fourth, that a purchaser for value and without notice takes free and clear of the trust. So you understand that's where you get the holder in due course. You see what I'm saying? So a lot of this stuff is ancient. It goes back prior to the creation of the UCC. The UCC is just a kind of uniform code to which all business and conduct is done. Professor Ames, says that it is clearly inaccurate to say that a Cestui trust is an equitable owner of the trust property, because the trust owner and of course 2 persons with adverse interests can't be the owners of the same thing. See, if your bank has an adverse interest to you, then how can a bank be An owner, they can't be. Because because you have to have mutual assent. Professor Maitland suggests that the Cestui Trust cannot be regarded in equity as the owner of the trust property because the law regards the trustee as the owner, and it would be inconceivable chaos, civil war, and utter anarchy if the law and equity should conflict. Now, it is probably true that the law and equity sometimes do conflict, but do they really conflict in this particular case? It is not really the fact that both law and equity regard the trustee as the legal owner, and that both law and equity regard the Cestui Trust as the equitable or beneficial owner. Of course, the question who is equitable or beneficial owner is not generally one which a of law is concerned. But even in Bacon's day, a court of law did sometimes concern itself with that question. And when it did recognize that it was the Cestui Trust who is the beneficial owner, to be sure, at first, equity did not like to call the Cestui Trust an owner of any kind, for equity was assisting in evasion of rules, the evasion of rules of law, which impose burdens or restrictions upon ownership. Once, say, Cestui Trust is real owner, say Maitland, it follows that he cannot make a will and on his death release, wardship and so forth must follow. But when at length it is decided, definitely determined how far equity should go in following the law, what legal principles are properly applicable to equitable interests, and what are not. When the law of trust became that noble, rational, and uniform system of which Lord Mansfield speaks, there ceased to be any practical objection to calling the Cestui Trust equitable owner. Okay. And courts of equity came more and more to speak of the Cestui Trust as having equitable ownership. And today it is submitted. This is a perfect, proper use of terms in which which accurately expresses the nature of his rights. 2. Equity acts upon the person. By judgment at law, the plaintiff is usually declared to have certain rights, have a certain right. By decree in equity, the defendant is usually ordered to act or to refrain from acting in a certain way. A judgment at law is usually enforced without cooperation of the defendant. If by the term of the judgment, the defendant, the plaintiff is declared entitled to a specific property, the sheriff puts him in the possession of that property. If by the terms of the judgment, the plaintiff is entitled to recover a certain sum of money, the sheriff seizes the defendant's property and sells it, and out of the proceeds pays the plaintiff the amount to which he is entitled. On the other hand, a decree in equity is usually enforced by imprisoning the defendant and thereby making things so disagreeable for him that he will generally choose untimely to obey rather than to continue to suffer the disagreeable consequences of his disobedience. Hint, hint. Now you have criminal court cases. See? but the defendant may sometimes be imprisoned on his failure to satisfy a judgment at law. And and on the other hand, by writs of sequestration and writs of assistance, the chancellor may enforce his decree by dealing with the possession of, or to a certain extent, with the title to personal property of the defendant, and by statute, of course, his power to deal with the property is greatly extended and includes real as well as personal property. Equity is not confined to action on the person, but but even if it were, it would not follow that equitable rights are only personal rights. Professor Cook has shown in clear, convincing way that the nature of a right is not determined by the nature of the action by which the right is vindicated, nor by the nature of the judgment or decree rendered in the action, nor by the method of enforcing the judgment or decree. 3. It has been urged that the duties which correlate with rights in rem are always negative, and that obligations which correlate with the Cestui trust rights are certainly not merely negative, although some do not, some doubt are negative, but some and most are positive, and therefore the rights of the Cestui trust are not rights in rem. But even if the premises are correct, the conclusion does not follow. So far as the Cestui trust has rights against the trustee to which positive duties correlate, the rights were indeed in personam. Um, but in so much as he also has a right to negative duties correlated duties correlate, he may certainly have rights in rem. Man, they are telling y'all some fire stuff in this if you paying attention. The trustee may owe a positive duty to invest the trust property. See, the trustee may owe a positive duty to invest the trust property. That duty does not rest upon the rest of the world. He may owe a negative duty to refrain from competing with the Cestui trust with respect to the trust res. That duty, since it is imposed on the trustee because he is the fiduciary, does not rest on the rest of the world. But the negative duty to refrain from using the trust property for any purpose inconsistent with the purposes of the trust is a duty which does rest upon the world at large. 4. It is, of course, fundamental doctrine of the law of trust that one, without notice of claims of the Cestui trust, obtains from the trustee a transfer of the trust res to takes the trust res free and clear of the trust. So if you understand this Cestui trust and holder in due course correlate. So let me show you. So holder in due course. All right. So this will make a lot of stuff, make more sense to you. Okay. All right. So 3-302, holder in due course. Okay. Subject to subsection C and section 3-106. A holder in due course means the holder of an instrument if The instrument, when issued or negotiated to the holder, does not bear such apparent evidence or forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. The holder took the instrument for value in good faith, what without notice that the instrument is overdue or has been dishonored, that there is an uncured default with respect to payment of another instrument issued as a part of the same series. So if you tell say if somebody transfers your interest to another person and then you let them know that the instrument is overdue and they still pursue legal action, good times, good luck with that. Okay, without notice that the instrument contains an unauthorized signature or has been altered, without notice of any claims to the instrument described in section 3-306, and without notice that any party has a defense or claim in recoupment described in section 3-305A. B. A notice of discharge of a party other than the discharge in an insolvency proceeding is not notice of a defense under subsection A, but discharge is effective against a person who became a holder in due course with notice of discharge. Public filing or recording of a document does not itself constitute as notice of defense, claim and recoupment, or claim to an instrument. What did I tell people about the UCC one? Everybody tell you follow UCC one. You got to know how to do it. You got to read UCC section 9 for you can follow UCC one. Okay, C, except to the extent a transfer or predecessor in interest has the right of a holder in due course. A person does not acquire the rights of a holder in due course of an instrument taken by legal process or by purchase in execution, bankruptcy, or creditor sale or similar proceeding, by purchase as a bulk transaction, not in the ordinary course of business of the transferor, or as a successor in interstate, in interest to an estate or other organization. Okay, so it's telling you a person does not acquire the rights in legal process. Okay. D, if under section 3-303, the promise of performance that is the consideration for an instrument has been partially performed, the holder may assert its rights against the holder in due course. So even if you partially performed it, meaning if you didn't even pay your full note, you can go against the so-called holder in due course of the instrument only to the fraction of the amount payable under the instrument equal to the value of the partial performance divided by the value of the promised performance. If the person entitled to enforce an instrument has only a security interest in the instrument, the person obliged, to pay the instrument has a defense, claim and recoupment, or claim to the instrument that may be asserted against the person who granted the security interest. The person entitled to enforce the instrument may assert rights against a holder in due course only to an amount payable under the instrument, which at the time of the enforcement of the instrument does not exceed the amount of the unpaid obligation secured. To be effective, notice must be received in a time and a manner that gives reasonable opportunity to act on it. Okay, this section is subject to any laws limiting statutes as a holder in due course.